Good evening and welcome to the Pittsburgh Public Schools Policy Workshop. Today is Tuesday, September 9th, 2025. My name is Jamie Petrosky and I am Chair of the Policy Committee. Tonight we will review Policy 202, Eligibility of Non-Resident Students, that is ready for consideration by the board. Ms. Elizabeth Sattler, an attorney with WBK Legal, will lead tonight's policy workshop, and I will hand it over to Ms. Sattler.
Good evening. Policy 202 is for consideration. Last year, there was a law change requiring a hearing before disenrolling students who the district believes are not residents of the district, but still attending district classes. As you can see, I've shared policy, a red line version of policy 202. The purpose of this policy is that the board shall operate district schools for the benefit of students residing in the district who are eligible for attendance. Under the authority is the board may permit the admission of non-resident students in accordance with board policy. The board shall not give priority for admittance to a non-resident student over a resident student in any case. And just to be clear, resident students are those who reside within the City of Pittsburgh School District border. This next statement in green has actually been moved. It's more of a guideline than authority. The next section of authority that I am adding is that the board reserves the right to verify claims of residency, dependency, and guardianship, and to remove from school attendance a non-resident student whose claim is invalid and who is not otherwise entitled to enrollment within the district. Prior to the change in the law, the school district could disenroll the student without a hearing. Now a hearing is required, and this is the additional new requirement. There is a hearing procedure. During the entirety of the hearing procedure, through the appeals process, the student must remain enrolled in the district. The first item to happen is that the district shall provide a written notice to the parent or guardian of the student or any other person who has charging or care of the student of the reasons for the district's determination to disenroll the student. Secondly, is disenrollment. This district may not disenroll the student until one of two things are satisfied. Either the parent or guardian or any other person having care or control of the student care have been provided an opportunity for a formal hearing and that the appeal process following that hearing has been exhausted. Or the parent guardian has been given the opportunity and notified of the hearing, but they have declined to participate in the hearing. The hearing is a formal hearing to determine residency of the student. A school district attorney or solicitor serves as the prosecutor, and a hearing officer presides over the hearing and issues a ruling. That ruling is then taken to the board to vote to accept or deny at a public meeting. From the date of the vote at the public meeting, either party has 30 days to appeal the ruling to the Court of Common Pleas. It would then follow an appeals process through at the Court of Common Pleas level. There are some guidelines within the policy. The first one is for homeless students. Prior to disenrolling the student, the district's liaison for homeless children and youth shall provide the parent or guardian with information regarding the educational rights of homeless students. In addition, if there are court orders related to disenrollment or enrollment, the district must comply with those. The provisions of transportation are the same, they've just been moved, but the board is not responsible for transportation to or from school for any non-resident student who resides outside of school district boundaries, except in accordance with law and board policy. And the board may admit non-resident students who are not residing within the district should they choose, and they may require students to pay tuition. The tuition rates are determined annually in accordance with law and charged monthly in advance of attendance. There are other guidelines related to non-resident children placed in a resident's home. So any child who is placed in the home of a district resident by a court or government agency shall be admitted to the district schools. Same for residents of institutions. If a child is living in or assigned to a facility that is located within the district, but that child, him or herself, is not a legal resident of the district, they are to be admitted to district schools. One other change is in red. The students experiencing educational instability. The district shall immediately admit students experiencing homelessness, foster care, or other forms of educational instability, even if the required documents aren't available in accordance with board policy, law, and regulation. And children of military families are eligible for enrollment in the district in accordance with the Interstate Compact on an Educational Opportunity for Military Children. Finally, the following provisions remain in the policy: that children of non-resident staff members are permitted to enroll in Pittsburgh Public Schools. However, transportation is not required for those students. Pre-adoptive students, that provision remains the same, and other non-resident students. And then this is the green paragraph was just moved from the top to the bottom. Finally, the superintendent or designee will develop procedures for the enrollment of non-resident students. There are some in place in this ARs. However, this policy change, the main provision that changes is the requirement now of a hearing to disenroll a student who the district believes is no longer or is not currently a resident of the district. And it's mandated by law. That's all I have, unless anybody has any questions.
Great. Do any board members have questions at this time? Seeing none. It's very quick and painless. And as a reminder, the policy will be available for public comment for 30 days before coming to the board for a vote. So if any questions come up in the meantime from board members and of course the public, they could be sent to myself as the chair of the committee, and I can forward that on to our solicitor's office. So going once, twice, 3 times for questions. All right. And then otherwise, this meeting is adjourned. Thank you, Ms. Sattler, for your time, and thank you, everybody in attendance.